Hi, my name is Akiva Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're continuing our video series designed to educate and inform the public, so please subscribe to our channel. The divorce process or the custody process, if there was no marriage, often has a litigation component to it, and then perhaps even a mediation component to it. Why do I say that? Well, if the parties could agree on exactly what's going to happen with little Billy, the case might not well even get into court. The fact that they cannot agree and the case is in court means you're already litigating and you are fighting about custody, parenting time, support, all of these things. The fact of the matter is, though, there are times when the courts, depending on which judge you draw, well, the courts may be more comfortable with deciding commercial issues, business issues, issues where the court doesn't necessarily have to step in the shoes of another parent, and the court can decide certain things based on numbers, based on the statutes and the Uniform Commercial Code or the commercial transaction statutes that deal with something. But when you're dealing with family, and you're dealing with people, sometimes the court would rather take another approach toward determining, for example, how many overnights does Dad get with the child and how many does Mom get. Oftentimes, therefore, the court will inject into the litigation process a mediation process. Now, if you're getting the impression that this mediation process might have been created so the judges don't have to make a decision, you're not wrong about that. I would think that a large component of that, though unspoken, is that the courts really don't want to tell you how to raise your kids. The courts want you to really try and work out what's best for you, because the courts, for the most part, figure parents are going to know better about their own family. If they need some help, the court will get the mediation process going, and to trigger that, we got to appoint a mediator. Oftentimes, the parties, through their attorneys, will agree on a mediator that they choose, that they have experience with, who they feel would be particularly helpful in this issue. Sometimes they can't, and then the court will just appoint a mediator. But a lot of deference will be given to the choice that the attorneys arrive at. And if they cannot agree who the mediator is, well, certainly at that time the court will appoint somebody that it uses and trusts. It'll usually be another attorney. And that mediation process will typically take place in the office of the mediator. And it's not the mediator's job to decide right or wrong, to decide who has merit, who doesn't. It's the mediator's job to essentially try to find the middle ground. Try to establish, through shuttle diplomacy, a way that the parties can work together on this, because there's a larger issue. And the larger issue is that once the courts are out of your life and the lawyers and the mediators, you're still going to be parents. You're still going to have to work things out. And maybe it's a good idea to get them used to try and working things out the way that the mediators use, the systems that the court uses, so that they can work out some of these disputes without having to bring the darn thing back into the courts. So there's a value in that. But the court often feels that if the parties get to a stage where they can't work it out with the attorneys through the litigation process, a mediation process will be superimposed on the litigation process in order to try to come to a resolution. Now, if you have any questions about your case, reach out, and we'll be glad to help you out.